All right. I am assuming that that was plenty of time for all of you to get through those first 10 questions. Um, so let's go ahead and start going over them. Let me unpause, play, there we go. Okay. All right. So a couple of things about Civ Pro. I'm sure all of you know that Civ Pro was added in 2015. There are not many real Civ Pro questions out there that exist. There are only 40 that have been released by the state bar. So in terms of, testing yourself with them, I mean, Barbie writes pretty much all of their own questions. If you're doing questions in Adaptabar, there are a lot of them are what they call simulated, which are ones that Adaptabar had people write. Um, so, it's sort of taking our best estimate as to, and knowing how the bar examiners write their questions, and writing them in line with that. But I would say that Civ Pro is probably the subject um, where people kind of, on the real bar, they'll, I'll kind of hear mixed reviews of, like I felt like those were totally different, or not. But the thing that I would say that you can do, and something that I often recommend, is that when you're doing any single type of bar question, any like other subject, on an MBE, you can often test yourself, on Civ Pro, because they will require you to use the Civ Pro standard. So it'll have some sort of, it'll say, so and so moves for a motion for summary judgment or moves for a new trial or whatever. So you can, um, so you can, sorry, so you can, take that as an opportunity to review those standards, because that is what's tested a lot. Um, so yeah, so that's basically, what I want to say about Civ Pro. But just know that when you're doing them, that know that when you're doing them, that a lot of them are simulated. So it's, everybody's in the same boat though on that. And for the mock bar that you're going to have with Thomas Jefferson in a couple of weeks, we do use the newly released. There were 30 questions in every subject released, in December 2017, and that's what's used for the mock bar. Um, so that TJ gives. So you guys should definitely all take that. And that's where and those Civ Pro questions are recently released questions. All right, that being said, let's get into some of these questions. So remember, the first thing we want to do is check the call of the question. And so what I've done here, it's like I've done on the last few, is I have highlighted what were the relevant facts. And pretty much the rest of what was in the question is, like red herrings or stuff that's kind of irrelevant or trying to lead you down a wrong path. So don't get fooled. And especially like if you look at the highlighting, if I scroll through here, well, save for question 4. But question 5, question 6, question 7, sort of, question 8. A lot of these, except for the last couple, the relevant information is actually at the end of the question. So if you go off of, if somebody asked if I'm recording, and I am, yes. If you go off just what it says in the front or at the beginning of the question, you will often, kind of get thrown off. So don't make up your mind about what the issue is until you get through the whole call, or until you get through the whole question. So all right, so let's start with the call here on question 1. So it says, does the federal court have diversity of citizenship jurisdiction over the action? So we're asking about diversity. So we know that that's either, a federal question or, diverse. So, and this is, well, no, it's just diversity of citizenship. So you have to have complete diversity, and the amount in controversy has to be satisfied, has to be over $75,000. So it says an elderly physician who performed consulting services, and it actually has $100,000 there. Performed consulting services for a corporation, passed away. Pursuant to a contract between the physician and the corporation owed the physician $100,000 when the physician died, so amount in controversy is met. Although the applicable law provides that such contractual debts survive the death of a party to the contract, the corporation refused to pay. Okay, corporation's being bad here, surprise, surprise. The executor of the physician's estate sued the corporation in federal court on behalf of the physician's estate, seeking payment of the sums owed. So they're giving you this detail about the executor because they're going to try to throw you off with it. But what you need to know is when the executor sues on behalf of the decedent's estate, it's the decedent's citizenship that matters, and then also that of the corporation. So the physician was a citizen and resident of state A at the time of death. The physician's executor is a citizen and resident of state B. The corporation is incorporated in state C and has a principal place of business in state B. So they're trying to trick you here by, making you think that the executor's citizenship matters, but it doesn't. So you have the physician is a citizen and resident of state A, and then the corporation is states B and C. So there's complete diversity, plus you have $100,000. So does a federal court have diversity jurisdiction over the action? And it's yes. It's the answer C here. Yes, because the plaintiff's citizenship is that of the decedent, state A, and the defendant is a citizen of both state B and C. So C is the correct answer here, and that's exactly what I was looking for. So I would want to check the others. So D, yes, because the plaintiff's citizenship is that of the decedent, state A, and the defendant's citizenship is just the state of its incorporation. We know that that's a misstatement of the law. It's both the state of incorporation and the principal place of business. So D is out. B, no, because the plaintiff's citizenship is that of both the executor and the decedent. That misstates the law. So B is out. It also says defendant, it correctly states the defendant's citizenship, B and C. Or A, no, because the plaintiff's citizenship is that of the executor. That misstates the law. And defendant corporation is also a citizen of state B. So if you didn't know that the executors, if you thought that the executive citizenship matters, then if you thought that mattered, then, and you thought that the plaintiff's or that the physician's citizenship didn't matter, then you would pick A, and A would be the correct answer. But that's not how the rule works. So C is correct. All right. So moving on to question 2. Does anybody have any questions about number 1? Okay, cool. All right, so question 2, can the court set aside the verdict? All right, so whenever you see a question like this, you want to think, okay, well, what are the bases upon which a court can set aside the verdict? So you want to, you should make a note of that. So if you get a question like this, so what you all should do is then, take a flashcard and make when can a court set aside a verdict? Oh, excuse me. All right. All right. So it says here, a plaintiff filed a negligence action against a defendant in federal court, alleging that the defendant caused a serious car accident in which the plaintiff was injured. The defendant pleaded contributory negligence as a defense. So here they're just giving you all the facts about what's going on with the case. There's nothing that says anything about the verdict yet, so I don't care. The court decided to use a general verdict with special interrogatories in this case. The jury returns a verdict for the defendant, but its answers to the interrogatories were inconsistent with the verdict and showed that the jury had failed to follow the court's instructions when it came to contributory negligence. So this is an instance where a court can set aside a verdict if it's obvious that the jury didn't follow instructions, and it is here. So the court has 2 options. You can either ask the jury to reconsider or it can order a new trial. So that's what I'm looking for. So A says that exactly. Yes, the court may either ask the jury to reconsider its verdict or order a new trial. So that's what I was looking for. It's right there. But let's eliminate the others. B, yes, the court may order a new trial. That misstates the law. So B is out. C, no, the court must enter judgment according to the jury's general verdict because a special verdict was not used. So that is incorrect. The court, if the jury has, even if you use a general verdict or a special, if the jury has not followed the instructions on the verdict, then the court can set it aside, or it can order a new trial. So C is incorrect. That misstates the law. And then D, no, a court can never set aside a jury's verdict. So that's incorrect for a couple of reasons. One, it says never, which that's an absolute, which should always be a big hint to you. So that's out. And then a court can't set aside a jury's verdict. So A is the correct answer. Any questions about that one? Okay. All right, let's look at question 3. Does a state B court have personal jurisdiction over the state B defendant? So we're just looking for PJ here. So we want to keep that in mind. Obviously you're looking for, either a general jurisdiction. You're looking for, sorry guys, 1 second here. Okay. Okay. Does the state B court have personal jurisdiction over the state B defendant? So, with PJ, so you're going to want to think about that. You're going to look for, is there a traditional basis for personal jurisdiction, or is there a long arm statute, and does it satisfy the constitutional test? I can just tell by this question that it's probably going to be a general basis because there's not enough facts in here to give me to tell me whether there is the constitutional limitation. Here it says, while driving in state A, state B resident was in an automobile accident with the state A resident. The state A resident filed a negligence action against the state B resident in the state B state court. So if the state B resident is sued in a state B court, the state B court has general jurisdiction over that person. So the court does have personal jurisdiction. So I'm looking for an answer that satisfies that. So let's just go through them chronologically or in order. A, no, because the action did not arise from the defendant's state B activities. That's incorrect. Doesn't matter. The court has personal jurisdiction. It doesn't have to arise from the defendant's state B activities if the resident is a resident of that state. B, no, because state courts do not have jurisdiction over actions that arise from events that took place entirely in another state. That doesn't matter. It doesn't matter that it occurred in another state. The state B courts have jurisdiction over state B residents. So B is incorrect. C, no, because the action is between citizens of different states and the amount of controversy exceeds $75,000. So only a federal court has jurisdiction over it. That's just a complete misstatement of the law. So C, that's a complete misstatement of the law. Obviously, state B court has court has general jurisdiction over state B residents. And then D, yes, because the state B defendant resides in state B and therefore the state B courts may assert jurisdiction over the state B defendant for any action. So, the big hint here was that this was the only yes answer, and that was the only I knew that the answer was yes. So that on its face pretty much eliminated A, B, and C, but I still want to go through and double check it. So that's question 3. Any questions about that? No. So Martha asked if I even thought about a long arm statute, and I didn't because it's not a federal court; it's a state B state court. So it's a state B state court. Yeah. So that's why. Okay, cool. All right. So let's look at question 4. Can the court grant the motion for summary judgment? So whenever I see them granting a particular motion, I always want to think, okay, well, what's the standard for that motion? So for a motion for summary judgment, it's the court will grant it if there's no triable issue of material fact. And I always forget, it's California and federal has it about the same. One of them says genuine issue and one of them says triable issue. But there's no issue of material fact, essentially. So a plaintiff sued a defendant in federal court for $200,000 in damages arising from an automobile accident involving the plaintiff's vintage sports car. The plaintiff alleged that the defendant had run a red light and caused the accident. So oftentimes when you'll see a dispute of fact regarding a traffic accident and who had the red and who had the green. So that's often I've seen that occur a few times when they're testing a disputed fact. But they also give you a detail. You want to pay attention to dollar amount. So here they're telling you it's $200,000 in damages. So there can be a controversy there, and there can also be a controversy regarding liability. So there are two disputes, liability and damages. So I'm looking for any issues with those. So I have $200,000 in damages. Then the plaintiff alleges the defendant had run a red light and caused the accident. and the defendant claims the light was green. Okay, so there it looks like there's a dispute there. The plaintiff files a motion for summary judgment supported by an authenticated surveillance video that clearly shows the defendant driving through the red light, as well as an affidavit from a vintage car expert who described the value of the plaintiff's car and the cost of repairing the damage. So the defendant cannot dispute the light issue. So that the court can grant summary judgment on, because there's no tribal issue material fact there. And then the plaintiff also provides an affidavit from a vintage car expert who described the value of the plaintiff's car and the cost of repairing it, so the $200,000. The defendant opposes the motion for summary judgment, but offers no supporting evidence regarding the color of the light. Okay, so basically the defendant is conceding that issue. He does, however, offer affidavits from 2 car experts who stated that the plaintiff's car was not nearly as valuable as he claimed, and that only $50,000 worth of damage was done to it. So there is a tribal issue of material fact. So there's the dispute with respect to damages. So the court here can grant summary judgment with respect to the liability, but cannot with respect to damages. Let me just double check the answer here. Make sure. Yeah, okay, good. So, and in California, they call it a motion for summary, partial summary adjudication, or it's an MSA. So they use slightly different terms in California if you get something on an essay that tests that. So just so you know that there is a little bit of a language difference there. But it's essentially the same. So A, yes, the court can grant complete summary judgment. It can't because there's an issue with respect to the damages. B, yes, the court can grant partial summary judgment on the matter of liability. That's correct. I know that's true, but I'm going to keep checking on the others. C, no, because there's a genuine dispute of material fact. So there is a genuine, they can grant it, but they can grant it partially. Just because there's an issue of, regarding one thing doesn't mean that that it can't grant it with respect to the other issue. So know that. So if you didn't know that the court could grant partial summary judgment, then you would probably have picked C. But that's just a misstatement of the law. And D, no, because federal courts do not have the power to grant partial summary judgments. That is incorrect. That's just a misstatement of the law as well. So B is the correct answer. All right. On to question 5. So these Civ Pro ones are fairly straightforward. I do strongly encourage you guys to do, like, when I went through these, you guys probably breezed through them. When I went through them, it took me like, I don't know, not even 10 minutes to get through the 10 questions. So I think that they tend to be fairly straightforward. So it's a really good idea to look at multiple different sources. So if you have Adaptabar, look at the Adaptabar questions. If you have, your bar provider, if you have Barbary, you have the questions from Barbary, and then you have the questions from us. There's a little Civ Pro supplement that I think is in the library. It's just Civ Pro MBE questions. You can order it. I think it's pretty inexpensive. You can order on Amazon. If you just do a Google search, you should be able to find it. You can look at the strategies and tactics books. They have the new one that has Civ Pro. Just because I think it's a good idea to get, different sources of it. Okay. So let's read the call to question for question 5. Did the lawyer violate Rule 11 of the Federal Rules of Civil Procedure when she signed and filed the complaint? So under Rule 11, an attorney signing every document except for discovery has to certify that after conducting an appropriate inquiry that the contentions are warranted. So I think that's another part of it, but that's the part that's relevant here. So a client related to a lawyer, the facts of a grievance against her former employer. And don't get that confused here. It says a client related to a lawyer. It's not that the client is like a family member. It's a client told the lawyer the facts of a grievance against her former employer. After investigating the facts, the lawyer drafted and filed a complaint in federal district court, asserting an employment discrimination claim under federal employment statutes. Okay. When the lawyer signed and filed the complaint, she believed that the claim had legal merit based on having worked on a similar case a year before. That doesn't matter. You still, this is why it's important to check the law every time you have a case, because law changes and you are responsible for knowing the changes in the law. So the lawyer did not know that the relevant statutes had been amended in the interim and that the amendments definitively precluded her client's claim. So the client's going to lose for sure. That's like definitively precluded. That means that the client is guaranteed to lose. The defendant served its answer, asserting the claim was without legal merit. So it doesn't matter that the defendant served its answer. It's a violation of Rule 11 to file a document that violates that had you conducted an appropriate inquiry before filing, that where you would have known the legal contentions were not warranted. So did the lawyer violate Rule 11? Yeah, absolutely. But let's just go through each of the answer options. So I see on here, I'm looking for one that says yes. So that brings me to C and D. And I'm looking, and D just states the appropriate rule. So yes, because a lawyer would have determined, had she conducted an appropriate inquiry before filing the action, that the legal contentions in the complaint were not warranted. So that just restates essentially the rule. It ties in the law and the facts. So D is a really good answer. Let's look at C. Yes, because she did not withdraw the complaint before the defendant served its answer. That doesn't matter. Again, you violate Rule 11 once you file it. So C is incorrect. There is something with respect to filing a motion for Rule 11 sanctions that before somebody files, so if somebody is not subject to sanctions if they withdraw their motion, but that's not what's happening here. This is just asking if it's a violation of Rule 11. So C is there. Like, you should all know that rule and know that there is something that deals with Rule 11, and I think that it's with respect to sanctions. So you should all know that rule. But that's not the correct answer here. And then let's look at the A and B. So C is incorrect. So A, no, because she believed in good faith that the legal contentions of the documents were warranted. That doesn't matter. You're a lawyer. You have to know the law. And you have to know you have to do a reasonable inquiry before you file an action. So it doesn't matter that she did it in good faith, and she did. So you might feel bad for the lawyer, but we have duties, and that's one of them. So A is incorrect. And B, no, unless a lawyer persists in prosecuting the action once the amendment is brought to her attention. That's also incorrect. That doesn't make you not violate the rule. You still violated it. You're just B again goes to the sanctions issue. That you're probably going to get sanctioned if you don't withdraw the claim. So B is out. So D is the correct answer. All right, let's look at number 6. May the buyer's attorney read the seller's deposition transcript into evidence rather than calling the seller to testify live. So all this is telling us is a buyer's attorney read the seller. So it's going to be a claim between buyer and seller. And I know that between parties, a deposition transcript can be read for any purpose. So I don't even really have to read the fact pattern here, and I know the correct answer, but we're going to go ahead and read the fact pattern anyways. So a buyer purchased an expensive antique car from a private seller. After discovering numerous problems with the car, the buyer filed a civil action in federal district court against the seller, alleging fraud. Prior to trial, the buyer's attorney deposed the seller. At trial, so now we have the buyer's attorney depose the seller. Okay, that's good. So we have the deposition. It was taken in this case. At trial, the buyer's attorney seeks to read the seller's deposition transcript to the jury as part of the buyer's case in chief. It's totally fine. You can do it for any purpose between the parties. The seller's attorney objects, arguing that any testimony from the seller should be taken live in court because the seller was in the courtroom ready and willing to testify. That's just not the rule. It doesn't matter if they're in the courtroom ready and willing to testify. The buyer might choose strategically not to put the seller on the stand because maybe the seller is particularly likable and you don't want the jury to if somebody's really charismatic, that can persuade a jury and they're going to not think that the guy committed fraud. So the buyer's attorney just might make that strategic decision. May the buyer's attorney read the seller's deposition transcript into evidence rather than calling the seller. And yeah, absolutely, because it's a deposition of an adverse party and it may be used at trial for any purpose. So A is our correct answer. Let's go through the rest. So B, yes, because the seller waived any objection to the depositions being used at trial by not objecting to its possible use at the time of deposition. You can't. So this misstates the law. That's not a thing. You can't object to it being used at the time of the depo. You can object to certain things coming in. That's why we make objections when we're in depositions, because we wouldn't want that coming in at trial. But that is the exact reason why you have to. That's the exact reason why you object when you're in a deposition. C, no, because depositions may be used as direct evidence at trial only if the deponent is unavailable to testify live. That misstates the law. And D, no, because a deposition may be used only to impeach the live testimony of the seller. And again, that misstates the law. So A is our correct answer. All right, we'll move on to question 7. And these ones had some interesting stuff, so I made some notes here. Give me 1 second. All right, so question 7, is the court likely to grant the manufacturer's motion? So somebody asked, what's the rule for objecting during a deposition? You have to raise objections during a deposition to preserve those objections should it be used at trial. So it's really just form objections that you have to object to if a question is inappropriate. But at deposition, if you don't do that, if it's later used at trial, your objection is waived. So that's why you have to object during a deposition. So question 7, is the court likely to grant the manufacturer's motion? Oftentimes, if it says that, if you don't know what type of motion it is, if you look directly above to like the sentence above, then it'll tell you. So here it says a motion for relief from a final judgment. So I immediately want to think, okay, well, what are all the bases for relief from a final judgment? And so I put the rule here. It's like on motion in just terms, the court may relieve a party or its legal representative from a final judgment, order, or proceeding for the following reasons. So mistake, inadvertence, surprise, or excusable neglect, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial. I highlighted that because that is, I'm going to actually highlight the rest of it. That is what is often tested with this question when it's asking for an appeal from a final judgment, and it'll vary. Sometimes I've seen multiple different fact patterns testing this rule. And sometimes the evidence could have been discovered with reasonable diligence prior to time, so like before trial. So I'll get back to that question that just came up. So the newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial. So they will give a question where you could have moved for it in time for a new trial, but didn't. So I've seen that come up as well. So like the thing comes up, the question comes up, or the example that I think of like that's recent is the alleged knife that was used in Nicole Kidman's death was found a couple years ago when the entire house and the entire property was torn up, and apparently it was dug up in the yard. So there's a question there as to whether, like, I think that's a little bit ambiguous. The murder weapon was looked for and it wasn't found, but that it probably, with a better search, it probably could have been found. So I don't think that would allow for a motion for relief from a final judgment. So that's an instance where it probably could have been found and the court wouldn't grant it. But let's look at this one. So an airplane passenger sued an airplane manufacturer in federal court after the passenger was injured in a plane crash. The passenger alleged that a defective part made by the manufacturer had caused the crash. The case went to trial and the jury found in favor of the passenger. Judgment was entered on March 1st. So then this is asking for a motion for relief from a final judgment. So judgment was entered, and you can move for a new trial within a certain period of time, but it says here 6 months later, and I know that it's more than I think it's 30 days or 60 days that you have to move for a new trial, but you guys should know that rule. 6 months later, an airplane parts subcontractor announced a recall of an engine part that had been found to be defective and was the likely cause of 2 previous plane crashes. So now this is something that the question is could this have been discovered? Until this announcement, there had been no indication to the public or aviation industry that this part was defective because the subcontractor had been very secretive about its in-house investigation. So here, it could not have been discovered. So this is the first time, this is the first time anybody could have really been aware of it. And then also, this engine part had also been in the passenger's plane. So in light of this new evidence, the manufacturer files a motion for relief from a final judgment. So is the court likely to grant the manufacturer's motion? And the answer is yes. The answer here is A. The answer is A. Because there was newly discovered evidence that by due diligence could not have been discovered in time to move for a new trial. So that just states the rule and it's applicable here, and it's applicable to the facts. The evidence here could not have been discovered. So A is correct. And it's for this reason that I highlighted down here for the motion from a final judgment. B, yes, because the original judgment is now void. That's incorrect. It's not automatically void. So that misstates the law. C, no, because motions for relief from a final judgment must be brought within 28 days of the entry of judgment. Again, that misstates the law as well. And then D, no, because the manufacturer should have filed a motion to amend a final order, and that's not correct. It's so long as you have you've met this rule, you can get a final you can get relief from a final judgment. So A is the correct answer. Let me check. Some people needed me to zoom in. Sorry, can you guys, I need last names. I have to take attendance for these workshops. So some people just have, like Jeff, I don't know your last name. Andrea, I know you. Laura, I know you. But it's also like the other professors have to know you guys as well. So if you can type in your name, that helps us. That just helps us in terms of keeping attendance. Oh, thanks. Got it. All right. So can you guys see that now? And I'm going to post this also to the twin page, so you'll have my notes. You'll have my notes. All right. Let's look at question 8. I'm going to zoom out. Actually, I can leave it right here for a minute. Okay, so we always start with reading and call the question. Does a federal court have subject matter jurisdiction over the action? So I think, okay, SMJ, like there got to be a federal question, or it has to be diversity of citizenship. For diversity, it requires complete diversity and the amount of controversy requirement. And the highlighted facts are these ones. So again, these are all at the end of the fact pattern. All right. So a sales rep who worked for a manufacturing company had an employment contract under which the representative agreed to work exclusively for that company for 3 years. All right, so it's probably going to be a breach of contract, which is going to be a state claim. But I want to get some confirmation of that, but I already think, so then I'm going to look for diversity facts. The contract provided that the representative would pay the company $20,000 in liquidated damages if he left the company before the contract expired. All right, fine. So there's $20,000, but it doesn't amount to $75,000 yet. 2 years into the contract, a competitor in the manufacturing company began communicating with the representative. 6 months before the representative contracts expired, he left the manufacturing company and went to work for the competitor. The manufacturing company is a citizen of state A. Okay, so there's manufacturing company. Well, both the competitor and the representative are both citizens of state B. So I have complete diversity there. So I'm looking for really facts that go to amount of controversy. The manufacturing company filed an action in federal district court against both the representative and the competitor. The complaint seeks $20,000 in liquidated damages from the representative for breach of contract and $70,000 in actual compensatory damages from the competitor for tortious interference. So the thing you have to know here is this is dealing with aggregation of claims for amount of controversy. And when you have two defendants, you can aggregate the amounts if they're jointly and severally liable. But if you have two defendants and there's two separate claims, they're not jointly and severally liable, you cannot aggregate. So here, the complaint seeks $20,000 in liquidated damages from the representative for breach of contract. So that's that claim against the representative. And $70,000 in actual compensatory damages from the competitor for tortious interference. So you cannot aggregate those two because neither one is above $75,000. So there's no diversity. So the federal court does not have subject matter jurisdiction here. So I'm going to look for one that says they don't have it because they do have complete diversity, but they don't have the amount of controversy requirement met. So D here says exactly that. No, because the amount of controversy requirement is not satisfied. That's a correct answer. That's exactly what we were looking for. So somebody asked, in pure comparative negligence, all defendants are jointly and severally liable. Yeah, but this isn't a pure comparative negligence case. This isn't like you're not suing multiple parties for negligence. There's a breach of contract claim against one person and tortious interference against another. So there are two different parties and two different claims here. Oh, I don't think in pure comparative negligence. No, that's just in pure comparative negligence are defendants jointly and severally. No, that's just the comparative that deals with the defense of contributory negligence. So no. Um, so does the federal court have sub SMJ? So D is the correct answer. No, because the amount of controversy is not satisfied. So if you didn't know your aggregation rules, then A would be the correct answer. Or you would think that A is correct, but it's not. So it says that says yes because diversity of citizenship exists and the aggregate amount of controversy is $90,000. You can't aggregate the claims here, so A is out. No, because the complete diversity of citizenship requirement is not satisfied. That's incorrect, so that misstates the facts. C, no, because the complete diversity of citizenship requirement is not satisfied, and that again misstates the facts. So D again is our correct answer. All right, so question 9. But again, did you see like how all the important facts are at the end? And I know that this is, you should. Barbary really does this a lot, and they're correct in doing it. They focus on this thing called negative priming. So which is putting all of these facts up front, like everything up here, to try to lead you down a different path and keep you focused on identifying what the correct issue is, and see if you can overcome that. So sorry, you keep asking me answers and questions in private, and nobody else can see your questions. So you've got to make your questions not private. Only ask a private question if you need it to be like if it's relevant, like just to you or something like that. Because or else nobody else can see it, and then it's like you and I are just having a conversation that's separate, and I need other people to be able to see it. So okay. So Barbary really does this a lot. I don't think that you'll see it every single time, but I've just noticed that it's in all of these questions. It's in all of these particular questions. So don't expect that every single time, but it is something to really pay attention to. And it's, the takeaway from that is to not get led astray. All right. Or I should say not get led astray by like red herring facts, which is something that just takes some time to get used to. All right, so question 9. Is the appellate court likely to hear the plaintiff's appeal? So as soon as I see this, I'm thinking, okay, well, what are all the bases upon which something can it be appealed? But I also know that, the first thing that comes to mind is you have to object to something in order for it, you have to preserve your right to appeal, that's another reason you object. So I'm looking for something related to that. So after closing arguments were presented in a federal civil trial, so it's federal court civil case, the judge gave all but one of the approved jury instructions that the plaintiff had requested. All right, so you gave the jury instructions. If the plaintiff wants to appeal the not giving that, then they have to object to it. Next sentence, the plaintiff did not object to the rejection of the proposed instructions. So plaintiffs waived the right to appeal that issue. After deliberating, the jurors returned a verdict for the defense, obviously. That's just, you can tell that's going to happen because the plaintiff's not getting what they want, and then they're going to say that that's the reason, that the failure to give that jury instruction is the reason for it, for losing. The plaintiff filed a timely appeal, citing as error that the judge's failure to give the requested jury instruction caused the jury to render its verdict in favor of the defense. So that's super predictable, but it doesn't matter because the appellate court is not likely to hear the plaintiff's appeal because the plaintiff failed to object. So that's what I'm looking for. So A, yes, because the judge's failure to give the requested instruction is considered plain error. So one thing I wanted to point out here, and I didn't type it for this one, but you all should know when which standard applies. So on appeal, what appeals are reviewed under a plain error standard? Option C is no, because the judge's failure to give the requested instruction was harmless error. So when does the court apply a harmless error? So you guys should be paying attention to that, and you should maybe make some notes on that. So definitely look at that. A is incorrect though because the plaintiff didn't preserve the right to appeal. And then B, no, because the plaintiff waived his right to appeal by failing to object and the judge did not give the requested instruction. That's correct. So that's exactly what I was looking for, is that the plaintiff waived the right to appeal, which is what happened here. So B is correct. C, no, because the judge's failure to give the requested instruction was harmless error. Like that might be the case, but it doesn't matter. We're not even going to analyze whether it was harmless error because we're just going to say plaintiff, you failed to preserve your right to appeal. So C is incorrect. D, no, because the jury verdict was rendered, which makes the jury instruction issue moot. That's just a complete misstatement of the law. The jury instruction issue is moot because they failed to appeal, but the jury instruction issue doesn't become moot just because the verdict was rendered. So D is incorrect. So B is the correct answer. All right, last one, question 10. Should the court grant the motion to dismiss? So you should know the basis upon which a court can grant a motion to dismiss. So let's look here. So a plaintiff properly filed a breach of contract action against a defendant in federal court, in the federal district court located in the defendant state. That state's rules of civil procedure provide that one may serve process on a defendant by mailing the summons and complaint to the defendant by certified mail to the defendant's home. So this is sort of sounding like an eerie question, but just it's sort of sounding like it, but you don't want to get too caught up in that. Pursuant to that provision, the plaintiff sent the summons and complaint by certified mail, but you're in federal court and you're applying a state service rule. But there is a federal rule where the federal rules of civil procedure authorize service of process pursuant to the law of the state in which the district court is located. That is a rule. They're testing on that specifically, which is our answer, option D there. So they're trying to make you think eerie, and they're trying to make you think that that's not okay. But all you have to know is federal court. There is a federal court that allows service and complaint according to the service rules of the state in which the federal court sits. So the defendants, pursuant to that provision, the plaintiff sent the summons and complaint by certified mail. The defendant's spouse signed for the documents and gave them to the defendant. So the fact that it says the defendant's spouse there, I'm like, okay, well, so was there proper service? And you can serve it on someone at the defendant's home of someone who appears to be of age. So the spouse suggests it of age because you can't get married till you're 18. I think that's the rule in every state now. Not 100% sure, but generally, yes, it is. The defendant moved to dismiss the action for insufficient service of process. So the only issue here is, could they serve it by certified mail pursuant to that state rule? And if you know that federal rule on point, you would say yes. So should the court grant the motion to dismiss? A, yes, because the federal rules of procedure do not authorize service by certified mail. So if you didn't know that there was that extra rule, then you would think that A is the correct answer, but it's not. B, yes, because service of process did not meet the requirements of due process. If you thought that it wasn't okay that they served them, the spouse signed for the documents, then you'd probably pick B, but it's okay. Because when it's served to the defendant's house, then it just has to be somebody of age that can sign for them. So that's okay. C, no, because the federal rules of procedure authorize service by certified mail. That's incorrect. They don't do that. They just have a rule that allows you to serve via a process that's allowed by the state, and the state here does allow that. And then D, no, because the federal rules of procedure authorize service of process pursuant to the law of the state in which the district court is located. And that's exactly, it just states the rule. So D is the correct answer. All right, any other questions about Civ Pro? We're going to do an essay next. Okay. All right, cool. All right. I will now, so there are, let me see. There are, let me just go to the twin page. There's two. So if you go to the workshop folder for Civ Pro, there's Civ Pro questions 1 and 2. Question 1 is a California civil procedure, and question 2 is just a regular civil procedure, federal. Which one do you guys want to do first? Everybody chime in, let me know. I think that, like, my personal opinion is that it's better to do Civ Pro 2, which is the federal civil procedure, because it covers sort of the bigger issues that are likely to be tested in California. And it's the California civil procedure one that they tested I think you guys are all going to see that from your bar exam companies. And I just also think if you get Civ Pro again, you're not going to get one that tests on these same issues. That just doesn't seem likely. Not that, I can predict it. So I think question 2 is better, but I heard from a couple people. Can the rest of you tell me? Okay. So we're gonna start then with question 2, just because in case we don't get through the whole thing, I want to make sure that we at least get through one completely. So that's what we're gonna do. All right. So do it's in somebody said they can find the essays. If you go to the twin page, the CBC twin page, it's in the Civ Pro workshop folder all the way at the bottom of course materials. And I can just email it to you, Myra, if you can't. Let me know if you still can't find it, but it should be there. Did everybody else find them? Huh. Because I just got them, but let me just double check my. Myra, I'll just email it to you right now. Okay, so it's 7:15, 7:16. I'm gonna give you guys 30 minutes. I want you to go through, do a full pre-write of this essay, and we'll go from there. So I want you to, outline all the issues, all the, match all the facts, triage it, etc. All right, Myra, they're on their way to you. And I'm going to pause the screen, and I will see you guys all back here then at 7:45. Thanks, Martha. All right. Are you guys ready to go? Or do you need another minute? Okay, cool. Good. All right. So first of all, what we want to do is first thing we always do is read the call to question, right? So we're going to read the call to question. If you can't tell what subject you're in based if you can't tell what subject you're in based just on the call, often if you look directly above, you'll see it in the paragraph right above. This one it's kind of like there's not a whole lot of facts. It's really a lot of it is just what the motions are on. So this one I think is somewhat straightforward, but there's a lot to get through. So that's what makes this one challenging. It's a time crunch. It gets through some of the big issues. PJ. It goes through PJ. It goes through removal, which requires you to go through SMJ, and then there's some collateral estoppel res judicata stuff. So I'm hoping you guys saw that those were the issues here. So the first, the calls the question: did the state properly grant doctor's motion to dismiss? Did the state properly deny Valveco's motion to dismiss? Did the federal court properly deny patient's motion for remand? So I know that's dealing with removals and SMJ. And did the federal court properly grant patient's motion for summary adjudication? So based on that, I made my list A. So I knew here, when I looked up, I saw that I basically said, in the 3 paragraphs above it, which are dealing with the motions, Doctor and Valveco each moved for the state court to dismiss the case on the ground of lack of PJ. The state court granted Doctor's motion and denied Valveco's. Valveco then filed a notice in federal court in State B to remove the case, so removal, so SMJ. Patient immediately filed in a motion in federal court to remand the case to state court. The federal court denied patient's motion. Relying solely on the judgment in the other plaintiff patient's action, patient then filed a motion in federal court for summary adjudication of the issue that Valveco defectively designed the valve. So that tells me that it's issue preclusion. So based on that, I made my list A. Based on that, I made my list A. I just knew that it was PJ twice, then remand, so SMJ, and collateral estoppel res judicata. So I actually, based on that, really made my what is really my list B, which is down here. So can you guys all see that well enough? Or do you need me to zoom in? Okay, cool. So I really made my list B based on that. So this one I was like, all right. So, from the outset, after just looking at those 3 paragraphs, I haven't read, so I've sort of read half the essay already. And then I just listed out all of what will be my heading. And then I'm going to go through and read the rest of it. And then I'm going to just start answering it. But I also listed here, just so you guys have it, what if I knew I was in Civ Pro, and if I knew that I was in Civ Pro, I would probably list the following. So it's this right here. So PJ, SMJ, venue. And then I list those things to remember to always look for those. And then complaint and service, discovery, motions, trial, and appeal. So I sort of list the order that things go in. And that for me triggers everything. I know everything that says it in Civ Pro just looking at that. Your list A might be different. If there's stuff that you always forget, then you need to add that. If you constantly forget about collateral estoppel res judicata, then you need to look for those issues. And you might list that. So your list A might be different from mine. And that's totally fine. It's something that's for you, that is going to trigger your recall so that you can remember to look for certain issues. So that's what you want. The thing I say about a list A is you've got to be able to write out the entire thing in less than a minute. So you've got to look at the call to question, write it all out, and that way you're on the hunt for everything. And it should really be everything tested in that subject based on the calls. So for me, that was fairly easy, but based on looking at the fact pattern a little bit. All right. So that being said, let's go through the fact pattern a bit. Somebody asked a question. Yeah. So see, this question is a lot for an hour. That's absolutely right. But when we get into it, you'll see that when you're given the same call twice or the same thing to analyze twice, it's going to be totally different. And in this one, I'll just tell you that you're not going to have to do an entire PJ analysis for the first call. And that might be scary for a lot of you, because I always say if you find that you're coming to a conclusion that that precludes an extensive amount of analysis, then you should probably keep going. But if you're going to do that analysis again in a minute for another party and you're going to complete the analysis, then that's the hint that you didn't need to go through all of it for the first call. So this is why pre-writing is really important, because it really does help you figure out where you're going to allocate your time. And that's massively important, massively important. So, all right. So let's start going through this. So doctor implanted a valve in patient's heart in state A, where both doctor and patient lived. So I'm looking at this. I'm like, okay, so that's where their residence, that's where they're domiciled. The valve was designed in state B by Valveco, so it's what gave rise to the action. Because I know that there's a design defect here, so that's where the substantial part of the activity took place. So there should be jurisdiction in state B over Valveco. Valveco was incorporated in state C, but had its headquarters in state D. So that tells me that Valveco's domicile is in state C and in state D. Patient was visiting state B when he collapsed due to his heart problems. Okay, so he collapsed when he was in state B. And I know that Valveco was designed the valve in state B, so that's where the activity occurred that gave rise to this action. So I think that the court probably has jurisdiction over Valveco there. But remember the doctor implanted a valve in patient's heart in state A, and both doctor and patient live there. So with respect to doctor, everything occurred in state A, and he's domiciled in state A. So patient visiting state B when he collapsed due to his heart problems. Patient decided to remain in state B for the indefinite future for medical treatment. So patient decides to remain in state B, so that means that state B is likely then going to be considered patient's domicile. So patient is now a state B resident because it says he intends to remain there for the indefinite future. So patient sued doctor and Valveco in state court in state B for $100,000, alleging that Valveco defectively designed the valve and that doctor negligently implanted it. So now he's suing both doctor and Valveco. So I think that, when I'm looking at personal jurisdiction, I don't think the court has PJ over doctor, and I really don't think there's any sort of counter argument. So I'm going to be okay with concluding that, but I'm just getting an idea of what's going on here. Defectively designed the valve and doctor negligently implanted it. Another patient had recently sued Valveco, alleging that it defectively designed the valve and had obtained a final judgment in her favor after trial on that issue. So that's telling me that we are dealing with issue preclusion. So that's really all of our facts here. So then we have doctor and Valveco each moved the state court to dismiss on the ground of lack of PJ. The state court granted doctor's motion and denied Valveco's. Valveco then filed a notice in federal court in state B to remove the case. Patient immediately filed a motion in federal court to remand the case to state court. The federal court denied patient's motion. And then relying solely on the judgment in the other patient's action, so it's using offensive non-mutual collateral estoppel. Patient then filed a motion in federal court for summary adjudication of the issue that Valveco defectively designed the valve, and the federal court granted the motion. So really, we're going through, there's not a whole lot of facts. It's really all within that first 3 paragraphs. So now I want to start going through and looking at the issues and matching up the facts. So let's start doing that. Can you guys read the blue if I do this? So traditional bases. Can you guys read that blue there? Okay, good. Okay, so traditional bases, I know what those are. That's the 3. That's domicile, consent to service. So if you're domiciled in the state, if you consent to PJ, or if you're served, if it's, some people call it tagging, but if you're served with process while you're in that state, present in the state, and none of those are here. So I'm gonna have to look for a long arm statute. It doesn't tell me that there is a long arm statute. So most jurisdictions have a long arm statute that apply the constitutional test. So then I'm going to apply the constitutional test. So assume state, this one we are in state B has one. So minimum context, purposeful availment. So for purposeful availment, the defendant must have purposely availed himself to the privileges and benefits of doing business or of being in that state. And here there's doctor implanted valve impedes heart in state A, and doctor lives in state A. Oops. There's nothing here. Nothing indicates doctor went to state B. So here it looks like there's no purposeful availment. So element 1, based on that, there's nothing that doctor did. So I'm going to say that, so that's all that we have to do for that one. Did you guys all get that? That you didn't need to keep going for doctor? Okay, good. I'm glad. Okay, yeah, you don't want to keep going here. So, and the reason that we know that is like, there's so few facts about the doctor. Like everything would have just been no, 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 no. And if you have something, so the way to avoid this, the way to avoid to keep going is if you come to a conclusion that like, no, this element is absolutely not met, and there's no counter argument otherwise, then you just stop. And there's no facts to go to any of the other elements. There's like nothing related, going to relatedness, to fairness, either. So that's what tells you. So I'm going to say court lacks PJ, and I'm going to say properly granted doctor's motion. So I like to put, I'm matching my facts in blue, and then I like to put my conclusions in red. So this is a really short issue. So there's PJ, you're done. But that now I know that on the next one that I'm going to have to keep going through it. So, all right. So now let's move on and look at Valveco. And so there are more facts about Valveco. So traditional bases here. So traditional bases. So there's domicile consent. There's domicile consent and service in the state. And they're not domiciled there. The place of domicile is in state C and D. So I'm going to list that here. And C and D. Objecting to PJ. No consent. Actually, can you do that? Yeah. So no consent. And there's nothing about where served. Oh, here. Sorry, you should put our conclusion up here. I forgot. Okay. So no traditional bases. And then long arm statute, this is going to be the same from above. So we're going to look at purposeful availment. Then we're going to go through and we're going to do the minimum context test. So minimum context. So purposeful availment. So you purposely availed yourself to state B. Let me see here. Let me just double check my answer that I wrote. Minimum contact. Yeah, designed its valve in state B. So here, so what you're looking for, so the facts tell us that it designed its valve in state B. In B. So designed its valve in state B, which suggests likely employed state B residents and rented property in state B. Like they might have done that. They might have rented property or something because they have employees there. So it looks like there's something going on there in state B. So I'd say that, so yes, they purposely availed. There's purposeful availment. And then relatedness. So I'll put my answer up here so you guys can see, but so relatedness. So it considers the nature and quality of the defendant's contacts with the forum state to determine whether there's general or specific jurisdiction. So it's got to be systematic and continuous activity with the forum such that the defendant's essentially at home in the forum. So specific jurisdiction exists if the defendant's in-state activity is less than systematic and continuous and the cause of action arises from in-state activity. So here, again, I don't think that you can say that this amounts to such systematic and continuous activity because they're not headquartered there. They're not incorporated there. They did have this valve design in state B, probably does not arise to systematic and continuous contact because it looks like business is primarily done in whatever state that they have their headquarters. In D. So I'm going to say not specific, and then but valve designed in state B by Valveco. So suit arose out of Valveco's contact with state B. So there it is related, and then we're going to go through fairness. So the convenience of the forum for defendant. So we're going to look at all of these. We're going to use the facts here, and you're going to probably use a lot of the same facts in this one. So and you want to make sure that you use every single fact. Make sure that after when you're reviewing, and if you have time, I mean, hopefully you do, and you're checking this in the last few minutes. Hopefully. Or actually, like even the last few minutes of your pre-write before you actually get into writing it, you're going through and you're checking to make sure that you've used every single fact. Because if you don't, that means you're missing an issue. So you need to look out for that. So here, for convenience of the forum for the defendant, so it's designed in state B. So designers who will be witnesses are probably in B, so it's convenient. The forum state's interest. So the forum state is going to have an interest in protecting its residents from being injured. B has interest in protecting residents from injuries and in not, I would say also like not employing and ensuring that people that work there who work in this state are not negligent. So the state does have an interest. So this weighs in favor of jurisdiction. So when the thing you want to do here, the one thing to watch out for is that when you're making a conclusion with these, when you're weighing factors, you want to say this weighs in favor of PJ. This in favor of PJ. Plaintiff's interest in convenient and effective relief. So this is where you use the fact about plaintiff deciding to stay there. So here it says that plaintiff, let me not italicize that, plaintiff visiting state B when he collapsed due to his heart problems. And so like right now I just realized, I was like, oh, the designed by Student Valveco, and I'd also the valve, it looks like the valve failed while plaintiff was in state B. And I realized I can use that for relatedness as well. So I can use that fact again. So as soon as I recognize it, I'm like, I see that it goes to another issue as well. Then I want to use as many facts as possible for as much as I can. So I'm going to use that up there as well. So plaintiff's visiting state B when he collapsed due to his heart problems and decided to remain in state B and for indefinite future for medical treatment. So for medical treatment, so I'm going to say that this also weighs in favor of PJ over Valveco. All right, so then judicial efficiency, you're looking at, what's going to be efficient for the court. And really a lot of things that you look at here is like the location of witnesses and parties, or not parties necessarily, but the location, how efficient is it going to be for the court to run. So it looks like, where am I going? Okay, so plaintiff lives in state B. So he's located there. The designers of Valve likely live in B, and witnesses Ray medical treatment and probably causation likely reside in B. They can testify that the valve is what caused the heart failure. Likely reside in B. So majority of witnesses are in state B, and easier for state B court to hear. So this also weighs in favor. Of PJ. I just noticed a typo, which okay. All right, and then policy. So this is just like, social policies. So there's probably a policy probably want to protect state B residents. This is usually what we say, residents, and then just overall safety. So this also weighs in favor of PJ. So all of the factors here weigh in favor of PJ. So I've gone over all of that. So then it looks like it was the court. Did the court properly deny Valveco's motion to dismiss? And I'm going to say yeah. State B court has PJ over proper. And I'm making notes because, I know that I would forget. I would just, have a conclusion that state B court has personal jurisdiction over Valveco, but I might forget to say, oh, yeah, there's, it properly denied. So that's why I make the note there, so that I personally don't forget about that. One other thing that I thought about while I was doing this, actually, no, it's not an issue. Never mind. Forget that. Okay, so let's look at the next issue. So then removal. So let me give you guys the rule here, just so you have it. So removal. So an action originally filed in state court may be removed by a defendant to federal court if the case could have originally been filed in federal court. But the federal court must have SMJ over the claim. So then we're just going to go through SMJ. So federal question. Is there a federal question here? It's no, it's negligence. So you always want to, you still, even though it's usually going to be a no, you still want to go through it. So federal question, this is defective design, so negligence. So not a federal question. Okay, so then we're going to go through diversity. So is there complete diversity? So this is actually where, so you have to look at so for patient, and then also Valveco. So that has to be complete diversity. So patient he lived in state A at time of implant, but decided to remain in state B for medical treatment. So the thing that this is what I was thinking about a second ago, is that you might raise a counter argument here. So I put an asterisk whenever I'm going to include a counter argument. So that's just my signal to myself that I'm going to include a counter argument there, just about where his domicile is, because you could make an argument that it was state A because because that's where he lived when it happened, but it's really going to be state B because that's where he's staying for the indefinite future. And because it's indefinite, there's no intent to leave, or he has the intent to stay there for the foreseeable future. So I'm going to make a little counter argument there, just because I know that I'm looking for a couple. But I'm going to say that domicile in state B. And then I know for a corporation, the place of domicile is where you are. Okay. All right. So now I want to look at Valco. So I know that the rule for corporations is where you have your principal place of business or where your headquarters are located. It's where where all the decisions are essentially made, and then also where you're incorporated. So I'm gonna go to so incorporated in C, headquarters in D. So then I'm going to conclude domicile in C and D. So then is there complete diversity? Yes. Amount of controversy. Oh, no, that's right. Oops. Sorry, hang on, guys. All right, amount of controversy here is for $100,000, so that's satisfied. Yeah, so Jeff, you asked about patient motion for remand. So I'm going to get to that. I'm going to say in order to analyze remand, you're going to ask, was removal proper? Because the defendant does have the right to remove. The defendant has the right to remove. So, and then I'm going through whether removal was proper, and then to say, okay, well, the mechanics of removal and remand. So I'll get to that in a second. And I'll get to that in just a second. Amount of controversy is 100,000. Okay, so where is it? Oops. There it is. So the reason, no, it's okay. I don't think I explained it clearly. So removal, because it does ask about remand. So because essentially you only remand if removal wasn't proper. So you say, okay, well, was it proper to remove the case? So that's why. So it's remand is proper only where you shouldn't have removed it. Does that make sense? Okay, cool. All right, and then just the mechanics of removal, how it has to be done. So you have to file a notice within 30 days, and all defendants must join or consent to it. So within 30 days, and then all defendants consent plus consent. And here, and it says patient immediately filed a motion to remand. Removal. Sorry. Let's see. Then filed. So they filed the notice to remove the case. So it doesn't tell us a time. It just says filed to remove. So it doesn't tell us a time. Patient if we immediately filed, but it does look like all of this is happening. So they sued, the court heard, and then they moved to remove it. So patient immediately filed the motion to remand. So it looks like the time has been met, and then since doctor is not in the case, Valco is the only one that needs to consent. So Valco is the only defendant. So then, that's probably, I'll change that. So we would have our rule here about remand, and then these are the issues we would all discuss. So proper removal. So did the federal court properly deny the motion for remand? And yes, they properly denied it. Yes, proper denial because removal proper. All right, any questions so far on PJ or on remand? Okay. All right, cool. All right, so then the last issue on this one. Did the federal court properly grant patient's motion for summary adjudication? Discuss. So here, the best answers would probably go through claim preclusion and issue preclusion. You don't have to do that. Like, this is really an issue preclusion question. And I know that because it's saying, like, they're trying to kind of scream it at you. Like, if they're trying, they know that this is a tough question because it has the full-blown, you start with one PJ analysis and you go through another PJ analysis that's complete. And then you go through all of an SMJ analysis. And then they're getting you to summary adjudication. And a lot of people just don't like collateral estoppel and res judicata for whatever reason. It's for a lot of people just have a tough time with it conceptually. So I think that they're trying, like, the fact that they're saying, they say issue twice. They're trying to tell you it's issue preclusion. So if you look in the third paragraph at the end, had obtained a final judgment in her favor after trial on that issue. So it's saying, like, issue. And then again, in the last paragraph, relying solely on the judgment and the other part of patient's action, patient then filed the motion in federal court for summary adjudication of the issue the valve could effectively design the valve. So it's really telling you to do issue preclusion. So when the bar examiners repeat stuff like that, they're trying to draw your attention to it. So pay attention to that. Like, they're trying to make it easy for you, because they know that this is complicated. And they know that you're in the height of an essay and that it's difficult. So that's really what we're looking at here. All right. So let's go through. So claim preclusion. So I'm like, all right, well, I'm going to try to get an 80, even, whatever, that's me. Right. But just in case some of you guys, went through it, I wanted to just say, so final judgment, on the merits. Oops, Command I, that's what I was looking for. There is a final judgment on the merits, because it's a final judgment. It literally just says that. And it's on that issue, i.e. on the issue of whether of the defective design. So there is a final judgment on the merits. So yes. But for claim preclusion, it has to be the same parties. So for the prior suit between another patient and Valveco. So there's not, you can't use claim preclusion. So let's just say no there. That's my little note. And then, okay, but then we want to spend our time in issue preclusion. So this is going to take a little bit of time. So it's got to be the same issue. So I'd have my rule and then I would go through each of the different elements. So same issue. So the issue here is that whether Valveco defectively designed the valve. So it's the same issue. In prior case and patient alleges Valveco defectively designed the valve. So same issue. So this is yes. Oops. Issue actually litigated and decided. So this is talking about the prior case. So was it actually litigated? So that means that there was a decision on the merits in that case, and it was. So obtained a litigate. Actually, should be in quotes. A litigated issue of whether Valveco defectively designed the valve because other patient obtained a final judgment in her favor after trial, and I'm going to just pull this on that issue. So it's on that particular issue. So that issue is actually litigated and decided. No. Sorry, this shouldn't be in italics. So that's a yes. Final judgment on the merits, it literally just says here, final judgment after trial. So after trial shows that it was on the merits, it's not dismissal for some other reason. On that issue, was the issue essential to the judgment? So here, you're going to talk about, so patient had sued Valveco, right, alleging that it defectively designed the valve. So issue is essential to the judgment, is essential, a final judgment in her favor on that issue. So like here, if you guys were actually in the exam, you're probably not going to be writing these facts all over a million times. You just can put like little quotation marks to show that like, okay, I'm going to use the same fact from above. As long as you know what that means, like this is taking me longer than it should take you in the exam. And I just want you all to realize that. So like encourage you to actually do this, because once you do this and go through it, you shouldn't have to look back at the facts again at all. Like you should not look back at the fact pattern. You're only looking at your pre-write and you're just typing and going from there. And you're not really stopping to think and pause at all. So I just wanted to point that out. All right, and then non-mutual offensive. So what that means is it's non-mutual, so it's not the same parties, and the plaintiff is using it offensively against the defendant. And it's okay if it's fair and equitable. And generally speaking, it's, you know, for the same issue, if the defendant had the chance to really litigate that and have all of those questions answered, and they did here. So fair and equitable because Valveco had a chance to properly defend defective design issue in prior suit. It was fully motivated to vigorously or zealously itself on issue. So that's what I would say. And then, so I'm going to say yes. All right, so can they use properly grant patient's motion for summary adjudication? And yes. The answer is yes. Because it's same issue, we answered yes to all these elements. These are all satisfied, so you're good. All right, any questions about that? All right, good. I will save this and post it. I posted the one from evidence. Sorry, I didn't realize that wasn't up. And I'll double check on the video too, because I don't know that that's up on it. It took forever to download it the other day. So I'll check on that. And then it's 8:30, so we don't have time to go through the other one. But if you guys have specific questions about it, definitely feel free to ask. And then we have the next workshop, I think is on Civ Pro. Civ Pro on Thursday. All right, everybody have a really good night. Good luck. Keep going. You guys keep going. You've got a ton of, it doesn't probably feel like it, but you do have a lot of time left. So I will see you all in a few days. Thank you.